we only have one in the courtroom right now. We're waiting on everyone else to be transported. The one in the courtroom is Mr. Lemus.
Does he need Spanish interpreter?
No.
And do you know, Ms. Lopez, if any of the individuals this morning will need the assistance of the Spanish language interpreter?
Mm-hmm.
I don't see anyone marked on the docket.
Nobody I talked to. Okay, so no, Your Honor, I don't think anybody does.
Thank you very much. Madam Interpreter.
Thank you, Your Honor. Call me if anything happens. The Madam Clerk can call me. Thank you so much.
We appreciate you. Thank you.
Thank you.
And Ms. Lopez, since we have Mr. Lemus Gonzalez present, can we go ahead and call that case first while we wait for the other individuals to be transported?
Yes, Your Honor, I'm prepared.
This is Mr. Lemus Gonzalez, case number RPC 2026-067862. The Public Defender's Office has been appointed in this case. Ms. Phelps, what is the state's position regarding his custody status?
Thank you, Your Honor. So, Mr. Lemus's behavior is very concerning to the state, and here's why. He has a pending DUI from just a little over a month ago. In that case, he was found to be passed out in the driver's seat of an off-ramp. The car was in gear and his foot was on the brake. I would note that in this case, his vehicle was stopped in the travel lane of the freeway and he was passed out drunk, allegedly. He was unable to stand. He exhibited signs and symptoms of alcohol intoxication, and he had an open container of the same type of alcohol that was found in his DUI from just over a month ago. So Mr. Lemus clearly has a severe alcohol problem, but he's making his problem everyone else's problem. Frankly, we're really lucky that no one was seriously injured or killed as a result of his behavior that's occurred twice now in less than 2 months. So there really, frankly, are no conditions that this court can impose to protect the community. The court tried to impose conditions in the other case, and it didn't work. I would note he was released on his own recognizance. He had a pretrial violation for a positive alcohol test. Pretrial services attempted to mitigate that risk by increasing the frequency of testing. And here he is again arrested for the same offense with very, very similar facts. So the state's requesting $15,000 bail for Mr. Lemus with pretrial services supervision with daily testing for alcohol if he's able to post, and a scram monitor. I'm also requesting that he be required to obtain a substance abuse evaluation and follow the recommendations. And I would encourage the court to impose the condition of absolutely no driving. He's not fit to be driving. I considered possibly a release to inpatient, but frankly, that's just too much of a risk with him right now. So I don't think that's appropriate at this time.
And the other pending case, Ms. Phelps, is in Sparks Justice Court, is that correct?
Yes, Your Honor, that's correct.
Thank you. Position of defense.
Your Honor, we do believe that there are conditions that the court can impose that would mitigate this risk to the community. I agree that a scram is necessary at this point. Showing up for testing was not sufficient, but there are other conditions that the court can impose other than holding him on a monetary bail that he can't afford. The scram is an excellent idea. We would also ask that the court begin the process for the PSS and for him to get an evaluation. We also think that a no driving clause would be appropriate. We reached out to his girlfriend, Christina. She confirmed to us that he is working full-time as a roofer, and he has been working there for 18 months. So he's pretty stable. She was also able to confirm his address and his phone number. So his corrected pretrial risk assessment score should be maybe a 3 or a 2 even. I think that if the court were to impose a scram device that continuously monitors him for alcohol and imposes no driving, this risk to the community would be fully mitigated. His criminal history only includes the DUI. There's nothing else. He's not committing other offenses or causing problems in the community. It's just that his drinking is obviously getting away from him. I would also propose to this court that when he comes back for arraignment, that he show that he's been engaging in self-help meetings such as AA or Smart Recovery or something similar. I think that 3 per week, as well as the scram device and beginning with the PSS would all go towards mitigating the risk to the community that this would continue to be a problem. That case that is out of Sparks, it's going to hold him as well. And so, you know, he doesn't really, he's only 20. He doesn't have a whole lot of assets. There's not a whole lot that he can pay towards getting out. So any of his resources really at this time should be going towards getting help and not so much, you know, paying money to these agencies that are engaged in the criminal legal system as far as release. Bail is not going to help either way. What he needs is to get started with treatment.
And Your Honor, I'm sorry, I meant to mention that he scored a 6 on the risk assessment, but he wasn't scored any points for pending cases. So it should have started at an 8 before Ms. Lopez's deductions. And I also just want to point out with regard to the suggestion for possible AA meetings or similar, we've received information that the AA, the groups don't like that. They don't like compulsory people being compelled to attend those meetings. It affects the way the meetings run for the participants who are there willingly. So they really don't like that. I know Judge Birchie was a big proponent of that initially, but I haven't seen her imposing that recently, and I believe it's for that reason.
Thank you, Ms. Phelps. Ms. Lopez, did I hear any response regarding Ms. Phelps' request to obtain a substance evaluation as a condition of release?
I think the PSS would cover it, Your Honor. It's a comprehensive. And so it would include substance use and mental health.
Like back where that third row, just turn around and move.
I can schedule the PSS for July 30th, Ms. Lopez,
Yes, Your Honor.
and you'll confirm that date, Mandy?
Yes, give me one moment. That'll be July 30th at 1:30.
July 30th at 1:30.
Correct.
July 30th at 1:30 p.m. for the PSS regarding his custody status. The court is very troubled by the allegations here, particularly that Mr. Gonzalez poses a significant safety risk to the community. However, I do believe there are non-monetary conditions that can be fashioned at this time, but make no mistake, this is the last opportunity and you will be expected to abide by all of these conditions. Otherwise, the court could take action against you, Mr. Gonzalez, and remand you into custody. So I will grant an own recognizance release. He'll be subject to supervision by pretrial services. He needs to report within 1 business day of release. He will be subject to daily testing or a SCRAM device installed. He's not to drive. He's not to possess any alcohol as he is not of age. He must complete the PSS. And he must attend future court dates. Otherwise, again, a warrant may issue for his arrest. His next court date will be an arraignment on July 30th at 9 a.m.
One of the issues I got. Yep, when I got housing.
I won't order the self-help meetings, Ms. Lopez, but I'll strongly suggest them.
Thank you, Your Honor. If
All
then,
right.
Your Honor, if we could turn to Mr. Hunter Gonzalez.
Yes. This is Antonio Hunter Gonzalez, case number RCR 2025-132466. It was continued at the state's request for compliance with Marcy's law. Is the state prepared to proceed at this time?
Yes, Your Honor, I'm just checking one last time for an update on the victim contact issue. And it looks like we've not heard from either of them. Nonetheless, the state is prepared to go forward. Your Honor, the state's requesting that the court retain the bail and on the amount set at the warrant at $25,000 bondable only. I actually think that's low given his history. With pretrial services supervision, I think supervision is certainly necessary and not just monitoring. No contact with the victims, Valerie Zamora and Taylon Martin Wilson as a condition and pursuant to statute, and no firearms or weapons. So as Your Honor can see, Mr. Hunter Gonzalez is in a wheelchair. It's my understanding that that's the result of injuries that he suffered as a result of this case. Essentially, he is alleged to have broken into the victim Valerie's apartment, wherein he told the other victim, Taylon, that he better beat it and his dudes are outside. He then proceeded to punch Taylon, kick him about the head, and then Taylon pulled out his gun that he was lawfully carrying and shot Mr. Hunter Gonzalez. And now Mr. Hunter Gonzalez is in a wheelchair. And frankly, Your Honor, I don't think he should get the benefit of any kind of mitigated. That shouldn't be a mitigating factor when considering his bail, because that's a problem of his own making. He does have criminal history. He's 21 years old, and he's got a misdemeanor conviction for domestic battery in 2024. He was also arrested in that case for assault with a deadly weapon and domestic battery by strangulation. 2023, he's got a felony arrest for assault with a deadly weapon and CCW. That case, the victims refused to testify out of fear of retaliation. That is literally what we were told. That case involved a gang dispute wherein Mr. Hunter Gonzalez pulled a firearm that he was unlawfully concealing, and he displayed it to the victims in that case and then passed it around to his gang member friends that he was there with. So he's a very high risk of continued criminal conduct. The state's requesting that the court retain that $25,000 bail bondable only, pretrial services supervision, no contact with the victims as a condition and pursuant to statute, and no firearms or weapons.
And is there an address associated with the no contact order requested, Ms. Phelps?
So yes, Your Honor, but I'd like to email that to the clerk.
Thank you. I'll include it's Taylon, Taylen.
Yes, Your Honor, that's correct.
Public defender's been appointed. Ms. Lopez, what's the position of defense?
Your Honor, we are asking for that owner recognizance release with conditions. We don't have any problem with the no contact order, either as a condition of his release or pursuant to statute. Mr. Hunter Gonzalez is willing and able to stay away from both victims and from the address. In addition, Your Honor, this is not necessarily mitigating. It's just a reality of his medical condition. The jail is just not equipped to handle his medical needs. We spoke to his sister. She confirmed that she and her brother both, they live across the street from each other. He can go stay with either one of them. We have an address if the court wishes. They can not only to help him take care of his medical conditions, but also get him to and from court. This previous case that has been, the state mentioned that he, as part of his criminal history, it's a 2024 case. And Mr. Hunter Gonzalez has been showing up to court, doing the things that he needs to do, checking in on time. One of the difficult, we have been set for a couple of orders to show cause, but it's not because of its non-compliance. It's more just to check and make sure that the community service that he's been doing will count, because given his medical conditions, it's been really difficult for him to find community service that would satisfy the court's requirements. So we've been coming back to court for a couple of orders to show cause. He has never been late. He has not missed his court dates. So he knows exactly what it is that he needs to do to remain compliant, and he's willing and able to do that. We talked to his family. His family said that they can keep him on track, and he's not really in a physical position to, go out and cause problems if the court is concerned about the safety of the victims here. So for all of those reasons, we do think that an owner recognizance release is appropriate and achievable. It can meet the court's needs as far as making sure that he comes back to court, and it can meet the court's needs as far as making sure that he's not in contact with the victims here. If the court is still concerned about him doing things that he's not supposed to do, he's willing and able to submit to a house arrest monitor. Our only request would be for him to be fitted with that monitor within 24 hours of release and not before being released, because Scram doesn't, they don't come and help equip that during the weekends or any off hours. And so if his family's not able to, pay for that and get that scheduled during business hours, then that's going to detain him up to several extra days. But for all of those reasons that we just put on the record, Your Honor, we are asking for an own recognizance release with any conditions that the court feels are appropriate.
The court finds at this time that the state has met its burden by clear and convincing evidence to establish it is necessary to set both conditions and a monetary amount of bail in this case. Particularly based on prior crimes of violence and an ongoing safety risk to the community. The court also considers the bail factors, including the nature of the sentence as that pertains to his risk of flight. I have heard and considered the mitigating argument offered by the defense. Therefore, I will reduce the amount. There'll be $15,000 by surety only, as this falls under the administrative order of the court. No contact, both by court order and pursuant to statute, with Taylin, Martin, Wilson, and Valerie Zamora. That's effective immediately. It applies to any communications from the Washoe County Detention Facility. The defendant must not contact and must stay 100 feet from those named individuals. That includes person, phone, text, email, electronic means, or through social media, either directly or through a third-party agent. And that is also pursuant to NRS 178.4845 for 120 days. If he posts, he'll be subject to supervision by pretrial services. And he's not to possess a firearm or weapon, as this is an alleged crime of violence. His next court date will be a 72-hour hearing on July 17th at 9:30 a.m.
Thank you, Your Honor.
Back is on. Blue Ducks.
Unless there's any other cases to call, Ms. Lopez, I can call them in the order that I have on my docket, but I'm not sure if everyone's here.
I know that we have Ms. Benson. We can start there.
For Mr. Hunter Gonzalez, he has an arraignment set for tomorrow.
Oh,
It was a warrant of arrest case.
sorry. The clerk is noting for Mr. Hunter Gonzalez that he is scheduled for an arraignment tomorrow.
That's fine, Your Honor.
All right. So if you'd like to call Ms. Benson, we can call that case next, Ms. Lopez. That is two matters, RPC 2026-067860 and 067861. We'll note that the public defender's office has been appointed. Ms. Phelps, is the state prepared to proceed at this time?
Your Honor, the state's requesting a one-day continuance for victim contact. I would note that we were able to contact her on the related case involving Ms. Benson's son, and she did appear at that bail hearing, and so the state does believe that the contact is certainly appropriate in this case, and that's what I would request.
May I respond, Your Honor?
You may, Ms. Lopez.
Your Honor, we would object to a continuance for Marcy's law. Normally, we would not, when the state is still trying to get contact information or when the state has attempted contact and was unsuccessful. But it sounds like the state has been in contact with her. And so I think that there's really no reason why contact would not have been made before today. So we would ask to move forward.
So my response to that, Your Honor, is it's a constitutional right of the victim, notwithstanding whether or not the state attempted to make attempts. It's actually not the state's burden to even satisfy Marcy's law. The burden is not placed on the state by any rule or constitution. The state just takes on that burden as part of this process. And so I still maintain that contact is appropriate, and I would request that continuance.
The court is going to pass this matter one day in order to facilitate contact. We'll hear this tomorrow morning at 9:30. The next case on my list is Latasha Bell. It looks like Miss Bell was unavailable to complete the application for the public defender's office.
I didn't know how to complete.
Would you like to apply for the public defender's office, Miss Bell, to represent you?
Sure.
Do you receive any government assistance?
No.
Nevada Medicaid,
Well,
Social
I-
Security?
Yeah, I do, but someone stole my card, so it's not, I don't have it on me, but yeah, I do.
Do you own any property? Do you own a home, a house?
No, not that I'm aware
Do
of.
you have? Do you have any income?
Not that I'm aware of.
All right. I will find that Ms. Bell is presumptively eligible for the public defender's office and appoint them to represent her in this action. She scored a 10 on the risk assessment. What's the state's position regarding her custody status?
Thank you, Your Honor. So Miss Bell has a very recent and actually relatively lengthy history of the same or similar offenses within just the past couple of years. She has a gross misdemeanor conviction for the same offense, indecent exposure, already this year. She's got 180 days suspended in that case. She's also got a gross misdemeanor arrest in 2025 for indecent exposure, same offense. She pled no contest to indecent or immoral show. Her suspended sentence was revoked just 2 months ago. She's got another misdemeanor conviction for indecent or immoral show in 2025. Then she's got additional criminal history going all the way back to 1998. She's got a felony conviction in 2023 for possession of a stolen motor vehicle, and just lots and lots of misdemeanors throughout her history. So she's a very high risk of continued criminal conduct, especially as it relates to this specific conduct. So the state is requesting bail in the amount of $5,000 with pretrial services supervision if she's able to post.
Your Honor, Ms. Bell indicated to me that she was under the impression that she had done everything that she needed to do to comply with that suspended sentence. And she was not aware that there were outstanding conditions at the time that she had her order to show cause. In this case, she indicates that she is willing and able to check in. She does not have a stable address. However, her local church is helping her out. She's not able to give me that church's phone number, but she does have people on the outside that are helping her. And so for those reasons, she says that she can and will check in with the court and she will show up. I note that she doesn't seem to have any scores on the MPRA for failures to appear. So it does appear that she does handle her court business when she has to. So we would ask that the court consider allowing her to be released on her own recognizance with check-ins.
There's a from 6 1 I don't know the name. Taking her backwards as well.
Court at this time will grant an own recognizance release in this case. She will be subject to monitoring by Reno Justice Court, meaning she needs to check in within 1 business day of release. But if she fails to attend any of her court dates, a bench warrant will issue for her arrest.
I get my court case. They didn't have, I did my time served last
Our next court date will be an arraignment on July 30th at 9 a.m.
We'll have all that. They get released here.
Good luck, Ms. Bell.
Thank you.
We get released by the-
Next case is Frank Cheshire.
Your Honor, he's not present and we are considering SB 89. So we would ask to set an interim bail and then perhaps a hearing. I don't know if he's got a 72-hour set already.
All right, he was passed from yesterday until today's date. So let me appoint the Public Defender's Office to represent him in this action in the interest of justice.
I will,
Sorry,
I
in
will,
both actions.
with edification, we have represented him in the past. So I believe that he likely, well, he still doesn't have any income as of today.
Right, so he will be appointed the Public Defender's Office in the 847 case and the 848 case. And I heard the request for interim bail. I'm inclined to set an interim amount of $1,000 on each.
Your Honor, no, the state would request $10,000 interim on each. There's lots of reasons for that.
Would you like to be heard further, Ms. Phelps? Ms.
Yeah, so
Phelps?
Your Honor, typically when defense requests interim, we don't have a whole bail hearing because that's reserved when they want to have the actual bail hearing. But I'm happy to explain to the court that there's lots of reasons for this. 2025, he has a felony arrest for residential burglary. That case was dismissed due to the failure to transport to Lake. So it's not that he necessarily didn't do it, but that there were competency issues. We couldn't get him transported to Lakes for a variety of reasons. He's got a misdemeanor arrest for destruction of property in 2025 as well, dismissed on competency. He's got a gross misdemeanor arrest for CCW without a permit and disturbing the peace. That's also in 2025. He's got numerous arrests in 2024, probation violation, trespassing. He's got a felony conviction for battery by prisoner in 2020. He's got a very, very lengthy criminal history. I would note he does score a 9 on the risk assessment. And there's the facts of these two cases, Your Honor. So first of all, the one where he went to the Bank of America and allegedly threw the rock through the window, and then 3 days later, he's throwing rocks at passing vehicles. He had a large rock in his hand, refused to stop, stepped toward officers, even when they had their gun drawn with the rock still in his hand, and then he took off running. So he's a risk to the community.
Hold on. So your request is for $10,000, but 10% would be $1,000 cash. Is that not what I said?
You just said $1,000, Your Honor, so I didn't know if you meant $1,000 with a 10% option, which would make it $200 for him to post. My request is for the $10,000 on each PC.
So bail said it, your request is $10,000 or 10% by surety or 10%, correct?
So, Your Honor, the state never concedes to the 10% option, but I do understand that that's what the court imposes.
All right. Well, given that it's interim, and we're not going to have the full-fledged bail argument, I'll go ahead and mark this as interim, Ms. Lopez, $10,000 by surety or 10%. If he posts, he will be subject to pretrial supervision, not to possess a firearm or weapon. And I believe it's no contact with Bank of America, located 700 North Virginia Street. And what will his next court date be?
It'll be a 72-hour hearing on July 17th at 9:30.
All right. Anything further on this case?
No, Your Honor, thank you.
Next is Silvio DeLucci.
Morning.
Public defender's been appointed in this case. What's the position of the state?
Your Honor, the state's requesting bail in the amount of $5,000 with pretrial services supervision if he's able to post. He scores a 10 on the risk assessment with 1 point for failures to appear. He's got a misdemeanor conviction in 2025 for lewd conduct in a public place and disturbing the peace. That was reduced from indecent exposure, which is what he's been arrested for here. In that case, he had multiple orders to show cause for failure to comply with sentencing conditions, and he failed to appear for a review hearing. He's got a harassment conviction in 2025. He's got multiple convictions in 2024 for trespassing, possession of drug paraphernalia, another possession of drug paraphernalia, contempt arrest, 2 failure to appear arrests, another failure to appear arrest in 2023, multiple misdemeanor convictions in 2023 for much of the same, trespassing, paraphernalia, multiple trespassing, multiple arrests for failures to appear, resisting. And it looks like he was unsuccessful in mental health court on a prior case. He was kicked out of Vitality and didn't turn himself in as ordered. So he's a high risk of both continued criminal conduct and future non-appearance. So the state's requesting $5,000 bail with pretrial services supervision if he's able to post.
Did I hear no contact with local parks?
You didn't hear that, but that's probably an appropriate condition, Your Honor.
What's the position of defense?
Your Honor, Mr. DeLucci doesn't have any monetary contribution towards his bail. So any amount of bail that the court sets today is going to hold him in custody. He indicates that part of what happened here is that he got off of his medications, but he recognizes that he does need them and that he is willing and able to get back in compliance with his medications. If that happens, if he gets back in compliance with his meds, he can and will check in with the court and show up when he is required to. So we're requesting that the court consider releasing him on his own recognizance with check-ins. I'm not sure that the other conditions are necessarily appropriate or necessary. He doesn't have a stable place to live. So having no contact with parks kind of takes him away from any free place that he's allowed to exist in our city. He is probably going to go to CARES campus if he is released, and that's where he will be staying. We do have the ability to check up on him while he's at CARES, as we do have people that are able to go on site, and we have a new agreement with CARES campus where we can share information. So with all of that being said, Your Honor, if he gets back in compliance and he gets into stable, at least at the shelter where it's a little bit more stable than being out in the street, we think that he can and will appear to court when he is required to do so. So we're asking that the court release him.
All in the football. And they're on it. So we try to-
The court finds at this time that the state has met its burden to establish by clear and convincing evidence that the defendant poses a risk of non-appearance and a risk of safety to the community. He has recent FTA history, recent conduct within this year, less than 12 months of similar conduct. The court does not believe that conditions, non-monetary conditions can be fashioned to ensure his appearance and his risk of safety. It will lower the amount of bail requested. It'll be $1,000 by surety or 10%. If he does post, he'll be subject to supervision by pretrial services. His next court date will be a 72-hour hearing on July 17th at 9:30.
Your Honor, the last person in the courtroom, although not the last person on our list, is Mr. Nelson Flores.
Are you ready to proceed on that case, Ms. Lopez?
Yes, Your Honor.
All right, let's let.
This is Nelson Flores Contreras. Case number RPC 2026-067867. Public Defender's Office has been appointed. What's the position of the state?
Your Honor, the state's requesting a one-day continuance for Mr. Flores Contreras for victim contact.
Do you wish to be heard, Ms. Lopez, regarding that request?
No, Your Honor.
The court will grant the request for one-day continuance. And this matter will be placed on tomorrow morning's 9:30 calendar.
But not. We.
And by my docket, we're waiting on Mr. Hinmers, Mr. Lopez Barajas, and Mr. Lopes.
Looking at the rest of them, Your Honor, I actually don't think anybody else is going to be transported. If the court wishes, we can start with Mr. Hinmers.
I'll come back to that.
Or what, we can go on in any order that the court wishes. It doesn't, nobody else is going to be transported today.
All right, let's start with Mr. Himners. That's next on my list. RPC 2026-067868. Public Defender's Office has been appointed in this case. He scored a 12 on the risk assessment. What's the state's position?
So, Your Honor, I would first just inquire with Ms. Lopez if Mr. Hinmers is waiving his appearance.
Yes.
Thank you. So, Your Honor, the state's requesting bail in the amount of $8,000 for Mr. Hinmers with pretrial services supervision with testing for drugs and alcohol. As Your Honor noted, he scores a 12 on the risk assessment. He was scored 2 points for failures to appear. He's got an active suspended sentence out of Reno Municipal Court, and he has had unsuccessful pretrial supervision in 2023. He's got a misdemeanor conviction already this year for petty larceny. He's got a misdemeanor conviction for possession of drug paraphernalia in 2025 with 2 failure to appear warrants. Looks like he has 3 separate convictions in addition to that one in 2025 for possession of drug paraphernalia, making that 4 in 2025. 2023 misdemeanor conviction for domestic battery and disturbing the peace. He's got a failure to appear in 2022. 2021, a failure to comply. Misdemeanor conviction for possession of drug paraphernalia, another failure to appear. Looks like much of the same between 2020 going all the way back to 2010 when he was convicted of possession of a controlled substance. He actually has another felony conviction for burglary in 2014. So he's very clearly a high risk of both continued criminal conduct and future non-appearance. So the state's requesting $8,000 bail with pretrial services supervision with testing for drugs and alcohol if he's able to post.
Ms. Lopez?
Your Honor, we would ask that the court consider getting started with the PSS with Mr. Hinmers and see if he is a good candidate for therapeutic court. I see that he's been unsuccessful on supervision before, but that was more like he was left to check in kind of on his own. And it sounds like Mr. Hinmers requires a little bit more hand-holding and might benefit from some more wraparound services. It sounds like here, although there are other charges that are associated with this, it sounds like the main issue here is that he was using and has drugs on his person. And so if you look at his criminal history, it also appears that drugs appear to be a long-standing issue in his life. So for those reasons, we would ask that the court consider inpatient door-to-door transport if he qualifies, and getting started with some assessments.
court finds at this time the defendant poses a risk of flight with recent FTA history. Therefore, monetary bail and conditions are appropriate. Bail will be set at $2,500 by surety or 10%. If he posts, he'll be subject to supervision by pretrial services and will submit to testing at random. In the alternative, the court will authorize direct transport to an appropriate inpatient facility through inmate assistance. His next court date will be a 72-hour hearing on July 17th at 9:30. The next case is Jose Lopez Barajas.
Your Honor, Mr. Lopez is also waiving his appearance for court. We are prepared to move forward.
Thank you, and I will note for the record, the Public Defender's Office has been appointed to represent him in this case. Ms. Phelps, what's the position of the state?
Thank you, Your Honor. The state's requesting bail in the amount of $3,000 for Mr. Lopez Barajas. So he scored a 14 on the risk assessment, which is very high. He was also arrested on a failure to appear warrant. Already this year, he was arrested once before on a failure to appear warrant. He has two 2025 cases out of Reno Municipal Court, both with failure to appear warrants. He's got a gross misdemeanor conviction in 2021 for conspiracy to commit burglary, a couple of misdemeanor convictions for possession of drug paraphernalia back in 2020, and then his history just goes on and on and on. But mostly due to that risk of future non-appearance, the state is requesting bail in the amount of $3,000 with pretrial services supervision with testing for drugs and alcohol if he's able to post.
Defense.
Your Honor, we're asking that the court release Mr. Lopez Barajas on his own recognizance with testing and supervision. He does have that case out of the municipal court. That bail right now is $1,406. He can't afford that at all. There's no amount that he can't afford to post towards his bail. I don't think that he has any money on his books or in his property right now. So, you know, this is a nonviolent offense. He doesn't score for violence. He does score in all the other categories. I do concede that, Your Honor. And it sounds like he doesn't have a stable phone number or a stable address. However, looking at the facts here, he was just riding his bike on the sidewalk at night. And it turns out that he had a warrant. And when he was patted down, the drugs were found on him, allegedly. So, you know, it's not very likely that he has, you know, additional issues in the community. It sounds like it's really just a drug issue. And if he checks in and tests, then that would mitigate the risk of future non-appearance. So we're asking that the court consider that today.
Thank you. The court finds at this time that the state has demonstrated by clear and convincing evidence that the defendant poses a risk of non-appearance. He has active warrant, very recent failure to appear history. Bail will be set at $3,000 by surety or 10%. If he posts, he will be subject to pretrial services, supervision, and testing at random. His next court date will be a 72-hour hearing on July 17th at 9:30. And that leaves John Lopes. This is case number RPC 2026-067869.
And Your Honor, he's not present and he's not going to be transported. We are actually asking to continue this, maybe set an interim bail today and consider setting this out to Tuesday. We're not sure at this time whether this looks to be an SB 89 or perhaps he just needs a little bit of time to settle in. But it doesn't appear that he can be brought to court in the, maybe even by tomorrow.
And Ms. Lopez, I would just note, he was found incompetent, it looks like last year in a case. And so, Your Honor, for interim bail, the state would request $5,000 with pretrial services supervision if he's able to post.
All right. So let's appoint the public defender's office to represent him in the interest of justice. I'm assuming they represented him on the previous case.
I believe so, Your
but
Honor.
I don't have that information in front of me. Bail, interim bail will be set at $5,000. He'll be subject to supervision by pretrial services. And can we schedule this on Tuesday, the 9:30? Yes. All right. So we will continue this case until Tuesday morning's calendar at 9:30.
Thank you. And Your Honor, I'm sorry, I meant to also request no firearms or weapons as a condition.
I will make that adjustment to the release order.
Thank you.
To the bail here,
It is, it's an interim bail set.
and then we'll just have another bail hearing on Tuesday.
We'll continue it to Tuesday.
Okay.
But you can note in the minutes that there may be a request.
Okay.
Any other items that were missed or any other
I-
matters to address?
I had Brittany Roberts on, Your Honor. Did she get released or did something happen?
I believe she was released. I checked the jail website. I don't see her on there.
Okay, I might have missed it. Then that would be
Yeah,
it.
she. Oh, large.
Oh,
Did I owe her? I released her on her own recognizance.
oh, thank you, Your Honor. Okay, then that is the list.
Thank you. Have a nice rest of your weekend.
Thanks, Jen.